Welcome back to Organize, the Business Law Breakdown. I'm Seth C. Oranburg, and we're back to Mastering LLCs with Episode 7, diving into the triple Ds, Disassociation, Dissolution, and Deadlock within an LLC. We'll see how LLCs die, and we'll look at ULLCA Section 601 and 701, guiding how members exit and how entities wind up. And we'll look at the famous Deadlock case of Fisk Ventures. More importantly, we'll compare how LLC law differs from partnerships, because a partner's departure can automatically dissolve the firm, and we'll distinguish it from corporations, where formal dissolution is a more rigid procedure. Sooner or later, members might decide to part ways, or the business might outlive its purpose, or it might run out of assets. Unlike corporation, where you need to file articles of dissolution and hold a shareholder vote, or partnerships, where a partner's disassociation can trigger dissolution automatically, LLC law offers a unique set of flexible but structured rules. Surprise, LLCs are a flexible hybrid of corporations and partnerships. Aren't you glad you learned about those first? Some members might want to exit while letting the LLC continue. Others might want the entire enterprise to wind down and make payoffs. A big question is, which path do you take? The ULLCA addresses two pivotal concepts, and I stumble over the words a bit, so you might hear me pausing as I talk about disassociation and dissolution. And these are two different things. Disassociation is when a single member departs, but doesn't terminate the LLC. Dissolution is when the LLC itself ends, and it begins the process called winding up and liquidation. So whether you're a multi-member enterprise facing internal strife or a single-member LLC planning to sunset the business, this framework matters for preserving value and relationship. We'll start with disassociation, and here we should look at Uniform Limited Liability Company Act, Section 601. Disassociation is where a member leaves the LLC. This can happen voluntarily, involuntarily, or on an event like death or incapacitation. ULLCA Section 601 outlines numerous triggers of disassociation, such as a member giving notice to withdraw, the member's expulsion by agreement of the other members or by a judicial order, or death of the member and sometimes even the member's bankruptcy. Contrasting this with partnerships, under many partnership statutes, particularly the older Partnership Act rules, the Uniform Partnership Act of 1914, a partner's departure dissolves the entire firm because the firm is an aggregate of its people, so it can't exist with a different set of people. There are newer statutes governing partnerships, and LLCs take a newer approach as well that says disassociation doesn't automatically cause dissolution unless, of course, the operating agreement says otherwise. And that crucial difference is partly because LLCs are conceived as separate entities and not a mere aggregate of the partners. LLCs typically presume business as usual until and unless the members decide otherwise. Once a member is disassociated, again, whether voluntarily or involuntarily, that former member loses management rights and loses authority to bind the LLC. They may be entitled to a buyout of their interest if the LLC continues. The operating agreement should detail a buyout formula. Otherwise, we default to statutory rules that may or may not be what you had in mind. So remember, if an operating agreement fails to specify what happens on a disassociation, there can be disputes over valuation or timing, and you might end up in litigation. So a practical tip is if you have a multi-member LLC, that operating agreement, which again I've referred to as the governing document, the constitution of the LLC, should have a clear buy-sell provision that deals with the situation of disassociation. Even if at the beginning of an enterprise everyone thinks they'll get along forever, they don't always. So it's a good idea to have that baked in. Let's now flip to Uniform Limited Liability Company Act Section 701, which deals with dissolution. Dissolution is about the LLC's entire termination. Here are some events that can cause dissolution. One is unanimous consent. If all the members agree to end the LLC, we're going to end it. It also might expire on a particular event or a particular time, so after a certain project ends. If it was only built in order to sell a golf course, once that transaction is consummated, the LLC might not have any purpose, and the operating agreement can write into itself that it will expire on that event. Or it could expire on a certain date, like in 10 years, which might be useful if it's a type of fund where you want to make sure that after a period of time, funds are returned to investors. It could also end because of a judicial decree. Court could dissolve the LLC if it's no longer practicable to carry on business, like in the case of Deadlock, or in some cases where there's been gross misconduct. And there is a concept of administrative dissolution. LLCs have to file regular reports and pay regular fees. Failing to file these annual reports or to maintain a registered agent can lead a state to administratively dissolve the LLC. In any event, once dissolved, the LLC enters a phase called winding up. First, they have to pay off the creditors, and then distribute leftover assets to members. This is akin to corporate dissolution under the Model Business Corporations Act, or the Delaware General Corporate Law, but there are typically fewer formalities and fewer mandatory filings. However, if you disregard a step in the process, personal liability might loom, kind of like veil piercing, and courts are particularly skeptical at the point where the companies are winding up and ending. This is an important time to pay attention to creditor claims and not issue funds to members before all the debts of the LLC are satisfied. Otherwise, you might end up in a veil-piercing type scenario. Another scenario that's a problem is called deadlock, and that's when members can't agree on major decisions. In corporations, a shareholder or board stalemate could trigger lawsuits, or a court could eventually appoint a custodian. In LLCs, once again, the possibilities are more flexible, but we can still end up in dissolution if resolution is impossible. And here we turn to the case of Fisk Ventures versus Segal. It involved an LLC with multiple factions. Key members disagreed fundamentally on financing and strategy, leading to operational paralysis. The court concluded that the LLC's operating agreement left them with no viable path forward, so the entity had to dissolve. And so we do see that courts will dissolve LLCs, even without wrongdoing, if you just can't move forward. So the lesson learned is that if the LLC splits into entrenched camps with no dispute resolution mechanism, like a supermajority vote or an arbitration provision, ULLCA Section 701A4 might allow a court for dissolution because it's not reasonably practical to carry on. Members rarely form an LLC expecting battles over buyouts or deadlocks. So what are some practical tips to avert this kind of meltdown? One is having a clear operating agreement. Spell out in the operating agreement the events that cause dissolution, like certain conditions or majority votes. Provide an exit strategy for members and have a formula to calculate buyouts. Second, include dispute resolution mechanisms in the operating agreement. Have a provision for what to do in the case of tiebreakers, like a designated manager with final say, a rotating tiebreaker member, or a requirement for outside mediation or arbitration, so there's a lesser path where the LLC can resolve its dispute without dissolution. And you could have put-call options. You could let a disassociated member put their interest back to the LLC, or let the LLC call that interest. Buy-sell options, in other words, so no one is stuck. If the operating agreement contemplates that in these cases you can simply sell off your shares or your units for a particular amount, or if the LLC can actually force a buyback of those interests for a particular amount, this can avoid dissolution as well. In other words, what we want to do is contract around dissolution by default. We don't generally want to end up in a situation where this kind of issue occurs because it has all sorts of moral hazard and holdup problems that we talked about in our agency chapter. And of course, the bigger the LLC, the more crucial it is to adopt robust procedures to handle transitions gracefully, because the more people you have and the more money that's involved, the higher the stakes and the higher the likelihood there could be issues. So that's our rundown on the triple Ds: disassociation, dissolution, and deadlock under the Uniform Limited Liability Company Act. We contrasted how LLCs diverge from partnerships, where an exit often triggers dissolution, and how corporations, where dissolution typically requires formal board and shareholder action. In an LLC, members can leave or disassociate without toppling the whole business. and the entity might only dissolve if it hits a statutory or contractual trigger, or if a court deems the deadlock insurmountable. Next time, in episode 8, we'll switch gears to some positive ends, like mergers, conversions, and entity transformations. We'll see how LLCs can morph into corporations, and how multiple LLCs can merge. We'll also discuss how these deals differ from traditional corporate mergers. But until then, I'm Professor Seth C. Oranburg, and I'll see you in episode 8.